the VRA.
Thank you.
Senator Tillis.
Thank you, Mr. Chair. Congratulations to both of you on your nominations. I watched your opening statements and much of your testimony from my office. And Judge Pryor, I was struck by how much your mother rides a roller coaster as you answer questions. She's going up and down, but she's obviously a very proud mother. I hope, and if I have time, I'll get back to you and ask you a question. Ms. Desai, you chose an area of the law that really requires you to wear a jersey, right? You're going to be if you're going to advocate for Democratic causes, you're going to have a blue jersey on. If you're advocating for Republican causes, you're going to have a red jersey on. So I'll leave it to the attorneys. I'm not one, but I'll leave it to the attorneys to ask the questions about the finer points of the cases that you've argued. But I am reminded of a district court nominee that we had in North Carolina who came before her, who had the red jersey on in election law. And I'm reminded of the fact that the questions that were asked from my colleagues on the other side of the aisle and the ultimate vote against his confirmation was driven purely by the clients you advocated for. I don't work that way. I do, like I said, I'll leave it to the lawyers to argue the reasoning behind some of the briefs that you've joined. But I want to ask more of a question because you clearly do have a liberal worldview. I'm not putting thoughts in your head, but if I can assume from the cases or the clients that you've represented that you have a liberal worldview. How do you, and you've clerked for the Ninth Circuit, but you do not have any judge experience. How do you make that leap? What life experience do you have that position you for serving on the Ninth Circuit? And how can I be sure that that worldview that you use to represent your clients as aggressively as you could will not influence the way that you decide cases on the bench?
Thank you, Senator, for that question. First, I want to note that I don't think it is true that some of my clients have been affiliated with Democratic causes, but I want to make sure that I note for the committee that I have represented clients, plaintiffs, defendants.
Give me some examples.
I have represented large corporations, Fortune 500 companies, small business owners. I've represented the government in many cases. And I have tried more than 70 cases to verdict and handled multiple dozens and dozens of appeals in matters ranging from business disputes, contract disputes, all the way to constitutional law issues. So my work as a litigator for almost 20 years spans a much broader range of clients and matters than just the ones, Senator, that you referenced.
I meant to say also that I think the only regret Senator Sinema has about her introducing you today is that it didn't happen yesterday on her birthday. She speaks very highly of you, and you've I think, advised her in her campaign. Is that correct?
Yes, Senator.
Judge Pryor, I was going to ask the same question that Senator Lee covered very well, but we have this ongoing debate about the plain text of the Constitution. I think you answered to a certain extent, but you have to apply it to modern challenges. We weren't contemplating the use of cell phones back in the day. But at the end of the day, is it a living document in that there are words in it that the Founding Fathers just didn't recognize? Or do you ultimately have to go back to the plain text of the Constitution when you're finally deciding a case?
When deciding a case, it is important that all my decisions are guided by binding precedent of the Supreme Court, as well as Seventh Circuit precedent, ensuring that I am guided by their decisions on what level of scrutiny to apply to a constitutional issue.
I just had one. Do you recall much of the facts related to Mitchum versus City of Indianapolis?
I do.
Can you tell me a little bit about why you ruled the way you did? And I think in the summary here, it had to do with the material facts and that the defendant I think in your opinion, presented several disputed material facts that he argues support a finding of the defendant's use of force in this case was unreasonable. Why was it unreasonable?
The court was unable to make that determination. As I outlined in that opinion, Mr. Tillis, it was important that the jury be given the opportunity to hear those facts. That's why it was denied on summary judgment, because the question was raised, or the argument was raised, regarding qualified immunity for those officers as to whether or not excessive force was used. The court could not answer that question based on the briefing and wanted to be able to present that case to the jury.
Okay, thank you. Thank you both. Congratulations again.
Thank you.
Thank you. Senator Blumenthal is recovering from COVID, and he was remote, but I think we have lost him. Is that correct? He's back on. Senator Blumenthal, can you hear us?